My name is Michael Franklin. I am a small claims assessment review hearing officer for the 4th and 5th Judicial Districts of the Unified Court System in New York. And I'm also a licensed New York State real estate broker. To qualify to be a SCAR hearing officer, you need to either be a lawyer, a former assessor, an appraiser, or a real estate broker. And I'm a real estate broker, and I have nearly 20 years experience valuing unique properties all over upstate New York. So I've had a lot of experience in observing what properties assess for, what they appraise for, what they list for, and what they sell for. So apparently the state felt that I was qualified to be able to value properties and perform the functions of a SCAR hearing officer. And having done so, prior to having been a SCAR hearing officer, I was an advocate for property owners, and I have currently more than 50 cases that I've participated in, and being a hearing officer, I've had an opportunity to function in 8 counties, and each county has approximately 20 townships, and of course each one has an assessor. So I have had an opportunity to see how many assessors operate, how they value properties, and how they treat taxpayers, and so on and so forth. And I've had an opportunity to see how taxpayers respond to the SCAR process. And so I want to review my recommendations for improvements to the SCAR process that I've outlined in the document that you see in front of you. Basically, the small claims law is a mandate to help assist in creating an equitable distribution of the tax burden, and to create an inexpensive and formal process to assist taxpayers for a review of property taxes. There are 2 forms that are I'd like to review. The RP 524 is a petition for somebody to go before the Board of Assessment Review. I think it's probably twice as long as it needs to be, and has verbiage in there that is confusing to taxpayers. The RPTL 730 is a small claims assessment review petition that is also 4 pages. It could be shortened to 2 pages, and it could be just greatly simplified. And I can review how it can be simplified. Also, I feel that the way SCAR works now is that it limits to owner-occupied properties, mostly residential. It doesn't allow for empty parcels or small commercial or rental properties that people buy and rent out. Those have to go to Supreme Court, and I found that not including those is abusive to some people, because some of them are very small properties. I had a case that was $15,000, and that he paid for the property, and they assessed him at over $100,000. And he has no place to go other than Supreme Court, and it just the amount of money it would cost and time to go to Supreme Court is beyond what it is that could be saved. It makes it to get if you were to have it reduced to what is just and proper, and I find that to be inappropriate. I'd like to see it opened up a little bit, and I don't think it'll have to cost the taxpayers any additional money. If we simplify the process, it should make it simpler for the clerk and the hearing officers to handle more cases more quickly. In order to, I don't expect the state to just take my word for this. There are 4 parties to a SCAR hearing. One is the clerk from the state, who doles out the hearing officers and the petitions that were submitted to the clerk from the taxpayer. So there's each county has a clerk that handles the SCAR petitions, and then there's the taxpayer himself or herself, and then there's the assessor as a party to it, and then the hearing officer, such as myself. So there's 4 parties to it, and my suggestion is that we solicit the input from each of these participants to see what they think could be done to make this process better, and not as cumbersome and not as frustrating, and not as inequitable as as it is. I believe the SCAR process is a good process, but it can be better. And these are the ideas I have to make it better. So I think the first thing, put a committee together and to solicit those ideas. But my ideas are is to analyze the Board of Assessment Review Form RP 524 and streamline it and shorten it and just make it simpler. Same thing with the Small Claims Assessment Review Form RPTL 730-A. That could be cut in half and greatly simplified. Also, the forms require that the petitions be sent to the clerk, the assessor, the treasurer, the school district, and the town clerk. I don't think anybody from the school district's going to read these petitions. I don't think the town clerk is going to read it. I don't think the treasurer is going to read it. The only ones that need it is the clerk, and the assessor. And it shouldn't be necessary to send hard copies. It could be emailed. You shouldn't have to. I had one taxpayer spent $42 in postage. It's ridiculous. It's unnecessary. We have the technology. We should be able to just email these petitions. It's just not necessary to make everybody go to the post office and go through all this hassle and discourage people from participating. It's just not necessary. Also, I'd like to see it be more inclusive to non-owner occupied, small rental, small commercial, and small land. I have examples of cases that show the inequities, and I'm going to be. I'd like to bring in some taxpayers who were abused by this and explain how it was abused by it. And again, the one case, the taxpayer bought the property for $15,000. He rents it out. The assessor assessed him at over $100,000, and he has no recourse. And I had to deny him access to SCAR because it wasn't owner occupied, and I just didn't think that was right. I had a case where a property owner bought a piece of land, and they had him assessed about $100,000 higher than it should have been. It's so perfectly obvious, but it was a piece of land he was building a house on, and so technically he didn't qualify for SCAR. He'd have to go to Supreme Court over $100,000 assessment. It doesn't make any sense. I had one where there was an empty parcel that was contiguous to their owner occupied house, but technically it's not. The parcel wasn't owner occupied, even though it was contiguous. Technically, that didn't qualify for SCAR. It should qualify for SCAR. It's ridiculous. It's a $35,000 parcel. You shouldn't have to go to Supreme Court over a $35,000 assessment challenge. That's likely to be a difference of opinion of about $15,000. It's crazy. It shouldn't be. I had a commercial property where it was a retail shop, and he was required to go to a state Supreme Court, and he did. And it took 3 or 4 years, and he won, and they had to give him a refund. And then as soon as the assessor was allowed to raise it again, they did, and he has to go to Supreme Court again to spend another 3-4 years. And the lawyers and all the time and hassle and aggravation shouldn't have to happen. It could be dealt with in a half an hour in a small claims assessment review hearing. It's completely unnecessary. I had another issue with one where, it's just a low-end property and the taxes were $1,000 a month, and we know that the budget has nothing to do with assessment, but the assessor, acknowledged that it was just crazy, but she says half the town is nonprofits, so there's just no tax base, and so it all goes on. The burden goes on these people. Hey, we need to tighten up these nonprofits, and people need to pay their own taxes. We shouldn't be having these people pay for other people's, organizations. It's just not right. And I had another one where the property owner's water frontage was calculated wrong for 25 years, and he didn't qualify for SCAR because they say it wasn't owner occupied because he put the property into his sister's name, for health reasons, and they're saying that his sister didn't live in it, so it wasn't owner occupied. It's just ridiculous. And so things need to be adjusted for equity purposes. Let me see what else we have here. On the bar forms at the end, the bars tend to just check the box and say insufficient data. That generates appearances of impropriety. They have to provide an actual decision to tell people that, at least so they can see that they actually analyzed it and were actually paying attention to their arguments. That's wrong. That needs to be fixed. Also, towns tend to hire assessors who will do their bidding, not necessarily assessors who are the best at generating fair market value and equitable distribution of tax burden. I believe perhaps the state needs to do some oversight on this, because I have seen, I had a town board member who is related to the supervisor, and she asked me straight up, she was concerned about people coming into the area and driving up the prices, and to me, they're trying to find an assessor that will take it easy on their local friends and tax the out of town people who are coming in and driving up these prices. No, it's fair market value, and it's just inappropriate. So again, in summary, form a committee to address the concerns. Don't just take it from me. 2, fix the bar form. 3, fix the SCAR form. 4, make SCAR more inclusive to all small claims. Small claim is small claim, whether it's residential or commercial. Number 5, require BAR to provide actual decisions to avoid appearance of impropriety. And number 6, state oversight of towns hiring made-to-order assessments, and cherry picking the assessors who will do their bidding. Again, this is Michael Franklin. My number is 315-876-2262. Thank you.